Everybody, my name is Jeff Fowler, president of the Apartment Owners Association. Today we're talking about e-scooters, e-bikes, and regulation around that. And our speakers today, they brought in an interesting piece of information that you need to know just right off the bat here. E-bike sales in the United States surged 269% between 2019 and 2022. And anyway, it's an incredible industry, and it is an issue. It's a safety hazard, and that's we've had to revise the AOA form related to it. Our speakers today made the revisions to the form, so I thought, hey, who better to have speak on this than the people who actually worked on that form and brought it up to date. So before we get into that, yeah, AOA's been around for over 40 years. Thank you so much. I know many of you are members, and just breaking news in this last week. Yeah, we have the sign, oops, there it is, sign behind me it says Prop 10, but no, it's not Prop 10, it is Prop 33 now. They finally came out with that. Prop 33, biggest threat to your investments that we've had, or definitely that's on the ballot this year. And we've sent out emails, we've written articles. We are gearing up to do a massive advertising campaign, and we need your help. Everybody's got to pitch in. And man, I'll say it, thank you so much. There are so many of you that have responded to those emails, and we've raised, yeah, just hundreds of thousands of dollars, all going towards advertising. So much more is needed. We got the AIDS Foundation that is for this Tenants' Rights or Act or Prop 33. They have like 13 million in this thing, and so much more is needed. So please open up your wallets and give to that. It is not tax deductible. We'll tell you that right off the bat. It is reported under California state law, so there is 100% transparency. You can see every dime that we spend, how it's spent. And I am happy to inform you that AOA covers the admin. So whatever you give, 100% of it does go directly to advertising. So just want to get that out there. If you don't give to us, our feelings aren't hurt, but give somewhere. We got to talk about this. We got to do everything we can, because even renters need to know that this is so detrimental for them. And if you don't know what I'm talking about, look it up online, Justice for Renters. Go to AOAUSA.com, type in Justice for Renters. You'll see several articles that we've written there. All right, and then also other in the news, we have LAHD just dropped their new tenant protection ordinance notice. It's the 2-pager, so that's brand new. So that's something that we are updating, and it's off to the printer. And we should have the downloadable version ready for you, hopefully early next week. And you can get it off the LAHD website, of course. And anyway, so there we go with that. You may have missed, we had a SB 721 balcony masterclass. We did that on YouTube last week, I believe, or maybe it was the week before that. Yeah, a week before that. So you can catch that and this one after the fact. Go to YouTube, just type in AOA USA, and there's a few different tabs there. The live tab has most of them, but some stuff we do just release. And so to not miss anything, we do recommend subscribing there. And there's a new California maximum allowable rent increase video that we did. So all those things go into effect August 1st. Obviously, it's too late to give a rent increase for August 1st now, but at least you know what they are. And the updated form in the AB 1482 section of the forms has the new chart that shows you what you can do for increasing the rent. At noon today, we have maximum allowable rent increases for the Bay Area. And in person, August 15th, we have habitability and landlord unit inspection rights. That is in person, August 15th. And then August 22nd, we have the AOA $1 million trade show. It's going to be amazing. Once again, there'll be over 150 different vendors that are there. And that thing already is just going to be incredible. Over 20 different speakers, including our speakers today. So there'll be just so many different resources for you between vendors and seminars. And you can already register for that. Go to aoausa.com and follow it's on the Hero banner. Just click on that, register. You only need to register once. Just register for yourself. It's free for everybody. Bring an unwrapped gift, and that is going to go to children that have a need. And anyway, so yeah, so much is going on, and so it's really a challenge, and it's fun to try to stay up with everything. And all right, so we're going to get into this. We have two different speakers from Dignity Law Firm that are speaking. And one of them has been a Super Lawyers Rising Star from 2016 to 2022, and he was named in the top 40, under 40 from 2018 and 2019. And that award is only given to the top 2.5% of young attorneys in California. And so that's attorney David Greene, so he's one of our speakers. And then also our second speaker, or co-speaker, I'll say, he was just recognized as Super Lawyer Rising Star for 2024, but he's been getting that award since 2021, year after year. And he also was just awarded the Best Lawyers in America, Ones to Watch recognition. And anyway, you'll see that he's sharp. These other people, they can acknowledge them, but when you hear them talk, you'll be able to also see that they know what they're talking about. And so this second attorney, extensive trial experience across various counties. He has recovered millions for his clients in diverse areas, and they've really been working with our members here a lot more recently, maybe the last 6 months or so. And anyway, so really a pleasure to have Joseph Kellener with us, attorney Joseph Kellener. So we have these two men. And I do want to mention 9 a.m. you'll be able to catch them at the AOA $1 Million Trade Show. So get there early and make sure you see them. If they start at 9, get there early enough to walk from the parking lot, get registered, and get in a chair by 9 a.m. so you don't miss anything that they have to say. And they're going to be talking about factual scenarios that cause an eviction prosecution to fail, and some strategies to avoid the tenant delay tactics. And man, I think that just knowing that is probably worth the parking. Even though the event's free, it's worth the parking, just that, because you could save literally tens of thousands of dollars just with that information alone. And then alternatives to litigation. So they're going to be covering a lot of different things. Wow, I talked for a long time. There's so much housekeeping, so much to do, but let's go ahead and get into it. So thank you, Joseph. Thank you, David.
All right. Good morning, AOA community. I hope everyone had a great 4th of July and enjoyed the fireworks. We are talking today about a exploding industry, both literally and figuratively, the e-bike, e-scooter industry. If you're here in Southern California, you have probably seen these around. They're ubiquitous on the bike paths and beach areas. Probably started with the Bird scooters that we all kind of came to know pre-COVID, but nowadays we're seeing more and more e-bikes, and they are becoming more and more common. In fact, my 15-year-old son has recently acquired one as a birthday present, and I have to say it's an unusual thing. But the reason this is so important is that because the industry is growing so rapidly, and it is a somewhat regulated industry, the regulations are catching up. And when your tenants or people in your properties start getting these devices, there are risks associated with it. These devices, if they are not maintained or stored properly, can explode. They can emit toxic gases, which can be danger to not only your property, but to everyone inside of it. They can cause fires, they can cause severe destruction and risk to property and persons. So fortunately, there are some rules that pertain to them, and there are rights that you as a property owner have with respect to your occupants owning and possessing and storing these devices. Joseph, my partner, who Jeff introduced a few moments ago, is going to go through some of those details. And there are specific types of devices that are okay. There are certain devices that are generally just not okay. And it's important for you to know what those are, so that if your tenant or your occupants come in with these devices, you are armed with the knowledge as to what's going to be okay for them to store and how to store it and what to do in the event that something does happen. We are always focused on protecting not only the owners of the property, but everyone surrounding the property, all the tenants, all the neighbors. The last thing you want is a severe liability because of something that ultimately someone else is bringing into your property. With that said, I'm going to hand it over to my partner, Joseph. He is going to kind of go through the form, the addendum agreement that he has provided or helped provide for AOA and AOA's members. And he's going to go through some of the legislation, the SB 712 that passed, that does allow tenants to have these devices, and some of the rules and restrictions around that.
Thank you, David. And I echo the sentiment of being here and providing this information and being invited back to speak to the AOA members. And we are definitely looking forward to being at the trade show and providing as much information as we can to help the AOA community, as well as those that are landlords and in this business. As David mentioned, when you have a particular item, like an electronic item or an item with a lithium battery, which is one of the key issues here, there are risks that are associated with it. We've all heard about those e-cigarette lighters with lithium batteries just blow up, or maybe your cell phone overheats, or things like that. Well, this is more important in a sense because this is a device that you are, based upon SB 712, allowed to store in your home. But if you're going to store something like this particular item, you have to look at the concerns for the safety of your tenants and your physical property. Clearly, fire damage and things like that spreads, and it could displace tenants. And these are things that are important, especially if it comes to potential insurance claims and accidents and things like that. So what's important for you, as we always talk about, is risk aversion. And in this situation, it's complicated because you're not necessarily going to know if your tenant has an e-bike. You may learn that they have an e-bike, but if you don't have an on-site manager or someone who's seeing it or able to deal with it, then this is something you can build into your lease agreement as a general addendum. So before you take a tenant, they're now aware of this e-bike addendum, and they're now aware of the rules associated with it. And I think it's important to kind of analogize it to waterbeds. When waterbeds first came out or were coming out, oh, okay, it was this big thing and you have this waterbed. Well, leases changed and they said no waterbeds allowed, because what would happen? There would be a leak, there'd be a break, you'd have hundreds of gallons of water and you'd have all these problems. So it's the same idea. When there's when there's an increase in a particular industry or a trend, there has to be the associated rules and safety risks that are maintained. One of the things that's important is under SB 712, the rationalization of the law is if you are a tenant or an occupant in a particular unit or wherever, it's up to one e-bike per person. It is not one e-bike per family. So if you have 3 people, 3 tenants, that's 3 e-bikes. So it's important to know that you are allowed up to 1 e-bike per tenant. Now, interesting is that built into SB 712 is the language of or. What do I mean by or? You're allowed to store an e-bike in your home or apartment if it meets one or the other criteria that's set forth in SB 712. And when you look at this form on AOA's website, you'll see that this is actually in the form so that there's no confusion as to what is allowed and not allowed. And that's the purpose of having a very clear addendum. There's going to be no debate. For example, if there is no motor whatsoever, which I guess one would say, well, how's that an e-bike? That's a separate question. But if there's no motor on this device, then you can store it inside. There's no problem. You don't have a motor, you don't have a battery, you don't have these issues. Now, if it has a electric motor or that lithium battery, there are two classifications that we sort of deal with. There are e-bikes and e-scooters. Those are not the same. An e-bike is what you may see where someone looks like they're riding a motorcycle. They pedal for a few minutes and off they go because they have this lithium battery and they actually have the ability to accelerate and decelerate using the handlebars and the respective controls. The e-scooter is what David had mentioned, which are those bird scooters and lion scooters and those things that we see around the city, but now they're being sold at Costco for $299. And anybody can buy one. And as you know, with pedestrian traffic, vehicle traffic, and things of that nature, people are preferring or choosing to buy this low-cost item because they can get to where they need to go locally pretty quick. And you can ride the bike lane or the sidewalk or things like that. So even though that's a separate issue, there are different. And the reason why I say they're different is because these e-bikes have a standard electrical motor system that has a certification. It's referred to as the UL 2849. The e-scooter has the UL 2272, which is the standard for the motor and the battery. These e-bikes are not home-built products. These are e-bikes that you buy at a commercial store. They have stickers on them that show the certification for the motor and the e-bike. Why does that matter? Because that's required. You have to have this particular standard or certification for the e-bike for it to be allowed to be stored inside the premises.
And I think just worth pointing out on that, as these industries come about, many of the manufacturers are not necessarily based here in California or even in America. Some of them are manufactured in other countries that don't necessarily follow the same stringent safety guidelines. So those two classifications are really critical for at least what's allowed now under the law, and you got to keep in mind that those may change and others may come into play. But as for right now, those are the two. And
David's correct. We have the United States Consumer Safety Protection Commission, which has its own form of regulations, and then you do have a European standard, again, depending on where the bike or electric vehicle is manufactured. Either or is acceptable as long as it is a proper certified product for that reason.
Joe, where are the European ones? Can you see them?
Yeah, the European standard is the Electrical Systems for Personal E-Mobility, and that's the EN 17128. And so hypothetically, if a person were to have an e-bike and you were to look at the underside of the e-bike where there's a serial number, there's going to be a stamp or a sticker certifying this particular item that it follows that certification. And so we had mentioned that no motor, you can store it. If you meet the European or United States framework, as I just mentioned, for the battery and the item, you can store it. But what's interesting is there's a number 3. And the number 3 is the tenant has an insurance policy on it. And that's interesting because if there is a policy that is associated with storing this item, you as the landlord, property owner, must be named as the beneficiary. It is not relevant to have the tenant have a policy for themselves in the event of damage because they're not getting compensated for burning down your building or causing a fire. So it's very important that when you choose, if that criteria is the one that's being met, make sure that this particular policy has you, the owner, landlord, indemnified or named as the beneficiary so that if there is a problem and you file a claim, you are going to get the proceeds from the insurance company to repair the damage or whatever was caused. And so again, the statute or the Senate bill and the respective form, it's the or criteria. One of the criteria must be met. That is the first part, to store it.
And recharge. Store and recharge. And also, just worth pointing out, even if they meet that criteria, it doesn't mean they can just store and recharge it willy-nilly. They still have to comport with fire safety. They can't block exits. You can't be doing this in a way that's going to jeopardize other people's safety or even the safety of the tenants in the event that something goes wrong. So that's all touched on in the addendum as well.
And to add to David's point, and it's built into the statute and the form, is that you are not allowed to repair or work on the battery per se inside the unit. You don't do that, period. A lot of people, and it's not a bad thing, but they may want to open up the motor, or maybe there's a problem, or they think they can fix it themselves. I understand the sentiment, but you can't do it inside. Because if you do it inside, working with batteries, working with things that are charged that way, that is the most perfect scenario for an escalation of damage or a problem. So it's very clear that repair or maintenance of the batteries or e-bikes is prohibited within a dwelling unit. But going back to what David had mentioned, there is the SB 712 uses the Office of the State Fire Marshal, Bulletin 23-003, and that's in relation to compliance regarding the scooters and how they are to be maintained. And to David's point, one example is charging the scooter. You are, even though that's not part of the form, but the background behind it is charging these scooters is not the same as plugging in your car to the charger and it sits for 10, 12 hours. These lithium batteries are concentrated power units that can easily overheat. And when you have 101 degrees outside, and then you're charging a battery all night, and I understand respectively, people do it, but you create these situations where fires can occur. You don't know the electrical system and how the house is run or if it's wired properly. So these are things to consider.
It's a recipe for disaster.
Right. And also attached to the e-bike addendum form is a sheet that the AOA is providing, which is actually the information bulletin from the fire marshal. And it clearly lays out safety tips, how to stop using the device or battery if there's issues, and also battery disposal. So these are important things that actually tie into the lease agreement. When you look at the AOA lease or a standard type of lease in similar nature, it has language in there that says the tenant is not to store hazardous materials or to dispose of hazardous materials at the property. Well, if you have this lithium-ion battery scooter, and if you take a look on your own and you read the bulletin from the fire marshal, and it says, for example, stop immediate use if there's an odor. Well, imagine that this tenant stops use because there's an odor, and rather than gets rid of the battery properly, decides to just throw it in your dumpster, and a fire starts. And so these are the type of scenarios which unfortunately are very plausible. So this form does not negate the other elements and rules of the lease agreements. It actually ties into it and solidifies a particular item. A lot of times a landlord may go to a property and say, wait a minute, you can't store that propane tank, against the window, or you have these bottles of chemicals or trash, things like that, clean it up. Well, here, now you're saying these batteries qualify under a potential dangerous or hazardous material and have to be stored properly or removed properly. And I think that's important to understand that different paragraphs of a standard lease agreement build in to the framework of the e-bike and its components. So it's actually harmonious to have this addendum to protect yourself in the event of an e-bike, and then on top of that, regarding complying with the other parts of the lease. And interestingly enough, unlike other topics such as whether they got a renter's insurance policy and whether you can evict or not, this, in my opinion, although it clearly has not been put to the test in my opinion yet, as David and I have handled hundreds of related landlord-tenant eviction matters during even just up to this part of the year, this is new. And so it's not new relating hazardous chemicals, materials, et cetera, disposal, control, and waste. What's new is whether this tenant has this addendum and what happens. And the reason why I say that is because just because they don't have a bike or a scooter doesn't mean they don't sign this addendum. This addendum is designed so that in the event that they choose to do it, they have to be in compliance. If you as a landlord determine that they have not told you or they're not in compliance, you have a right to pursue this, but my recommendation would be before any litigation or any notice,
make sure
have that conversation with your tenant. A lot of times, and I've seen this lately, there is a lack of personal communication or a relationship with your tenant. I understand if you have a very large building with 700 units, that's different than if you have 2 or 3 buildings with 5 or 6 units. My thought process is a lot of times issues can be resolved with good communication and making sure that the landlord-tenant relationship is healthy. If you're aware of an e-bike or e-scooter thing, you reach out to the tenant and you say, hey, I realize you got this thing. I just want to ask you, can you please confirm that it has one of the certifications, that how are you storing it? Please make sure you don't work on it. Remember, you signed that addendum. Can you provide me the information? For example, if they say there's an insurance policy, and we've talked about this before regarding documents that they claim are an insurance policy or not, verify it. They give you that policy, call the company and say, hey, I want to make sure this is an active and valid policy. I've been named as the beneficiary. I want to make sure it's paid up to date on what's going on. And that's important. And where I started with this comment was, if there is a lack of compliance after signing this addendum, in tandem with the storage and disposal of hazardous materials, you have grounds for a cure or quit notice.
Yeah, we expect to see this as a rising issue in landlord-tenant matters, and we hope that this information gives you a baseline to not only be aware of what's going on and be informed about the laws, but to protect yourself, protect your property, and to make sure your tenants are complying with the laws so that you don't have liability you don't need.
And I would just add, it's not a quit notice. It's a cure or quit. And if they don't comply, it's the subsequent quit notice. This is not what I consider one of those material under Civil Code 1161.4, which is the section where it's just a breach. There is no cure required, which is section 0.3. That is important to know, because my position would be that if a landlord just serves a quit notice, that will fail. This is a correctable issue. And it's important to know that, because you don't want to serve the wrong notices and go down that respective path. So again, have your tenants review this addendum and sign it. Make sure they understand it. With this form that the AOA has put together, there is the bulletin from the fire marshal. So that is it's a 2-page form in a sense that can be used. And then I would also say that in relation to an issue, talk to your tenant first. See if you can work something out. Assuming you can, the issue is resolved. If you can't, then you can move to the cure or quit notice and the quit notice. And I do believe that when you look at the main lease agreement, along with the addendum and the respective violations, you will be able to successfully address this issue. And I would just add, for my closing comment on that subject, evidence is crucial here, and it's a little complicated, because you have to necessarily prove that the bike is not in compliance, and you have to show that the bike is being stored or being used in an improper way that contradicts SB 712. And how I suggest that's done would be in the cure or quit notice. The cure or quit notice is not simply going to say you're storing the bike improperly. The cure or quit notice would say something along the lines of, it is on information and belief you're storing the bike, it's been seen. This is a cure or quit to show us the bike that it is either doesn't have a motor, has the European or USA standard, or that you have an insurance policy naming the landlord as the beneficiary. Then you actually close out that loop, because you're saying, just show me that the bike is proper, or the scooter, and then I can go ahead and I can deal with it accordingly. So I think this is going to come up. I think that tenants are going to try to be savvy, and they don't listen. So it's really about diligence on behalf of the landlord, apartment managers, and those associated in the business, because you don't want the outside consequence where there is a problem, there is an issue, and now you're left with catastrophic damage, other tenants that may be claiming that there was some sort of negligence on behalf of the landlord, and it just creates a very, very dangerous situation.
Great. Well, thank you. And now is a great time to ask questions. If you're watching on AOAUSA.com, there's the blue help button at the bottom. And just if you get a question in there, they'll funnel that over to me, of course, on YouTube and Facebook. You guys know what to do to get questions in. And just real quick, I know one of the questions, I don't see it up there yet, but we already have tenants, right? And so, yeah, putting this with a new lease, that's real understandable. But how do I get, what's the process to go about giving this to, or how do you approach a tenant with this and having an existing tenant sign this? What would you recommend?
So this is not an addendum that is what I call some sort of secret or damaging thing where a tenant would look at this and say, what is the landlord trying to do to me? I think that this is an addendum that is designed for the purposes of protection and having a mutual understanding in the relationship with landlord-tenant. This is not in the form, but under SB 712, it says a landlord shall not prohibit the storage of such an item unless it does not comply. So you cannot turn around and say you're not allowed to do that. What you are supposed to say is you're allowed to do that as long as you're in compliance. That is a different framework for introducing this issue. And I think it's important. You can send out a letter or a general notice, please be advised that we are going to be sending a form regarding an addendum for e-bikes. If you have an e-bike, please review and sign. If you don't have an e-bike, we still would like your signature, but it obviously does not relate to you. And this is kind of like when you see the lead-based addendum, the mold-based addendum, and these different documents. If a tenant were to resist this issue for whatever reason, that would be very concerning to me. Because unless they're running an e-bike motor business out of their home, there's nothing, there's nothing here that hurts them. All you're saying is, look, these are the rules now, and you need to comply if or when you get an e-bike. So,
as new laws come about, it's always a good policy to notify your tenants and let them know that the new laws have passed, and here's how we're responding to it. That is what a responsible property owner and landlord would do, and we encourage that type of communication.
And then also just in this area, to be compliant, like you want to see that they have the certification. You mentioned the European one, the two different American certifications. Would you just request that the tenant snap a pic and send that to you?
Take a photo, send it over to us, or set up a time and a place where you can take a look at the e-bike or the mobility device and confirm for yourself that it is meeting the standards.
I would add to that, it's kind of like when you rent a parking spot and the building says, okay, let me have your license plate so that we know that your car is associated with that spot or something along those lines. As a landlord or a property owner or the combination manager, when you have a product that has a potentially dangerous issue, they have serial numbers, they have manufacturer information, and they have the certification sticker. Having that information is not confidential or secret. It's actually beneficial to you in case there's an issue or a problem with this particular device. You now know where it was manufactured, you have a potential serial number, and you have a copy of this document. And for those of you that have insurance on your own for the building, that may be a good talking point with your insurance carrier and saying, hey, this law came out, tenants may be storing these things. I want to make sure that I have the information necessary in the event of a claim. And I have never seen any accident, whether it's a car accident, an appliance accident, whatever it is, where they say, what was the product? When was it purchased? Who was the manufacturer? And all that information. So I think it's a great idea, just like you keep general files or general information, to get that information and ask that it be updated in the event there's a new scooter or something like that. So I think it's a great idea, informally or formally, to get that information in your file.
So and here's just one other question. So you make routine checks to make sure that the smoke detectors are working. At that point, maybe incorporating this check into that, maybe?
Yeah, I think there are many ways to skin a cat, so I think that you've got to really base it on your relationship with your tenants, how you do your periodic inspections or your maintenance at your property, and make sure that it's not too intrusive and doesn't come off as a targeted or harassing conduct. but I don't think there's a wrong way to necessarily do it.
And I would add to both Jeff's question and what David said, Civil Code 1954, which is the code section that talks about access. There is not a checkbox or an access point for an e-bike. Conducting smoke detectors and fire tests, dangerous situations, proper notice for repairs, maintenance, things like that, or with permission is the common framework of Civil Code 1954. So to just post a notice that says an inspection for an e-bike could be problematic. So
Right.
what you want to do, as mentioned, is it's actually a very smart idea to incorporate that into a fire and safety standard protocol, such as smoke detectors, bikes, things like that, so that you do have the ability to inspect that. And I would add to Jeff's point, a landlord needs knowledge of what is going on at their property. Absentee landlords or just relying on a property management company and having no knowledge is an issue because there's imputed liability and indemnity issues from the property manager to the landlord. But you don't want to be that landlord who has no idea that everybody in your building has 2 e-bikes. You just don't want that's not helpful. It's better to know your tenants, know what's going on, have the relationships. And imagine how good it would be if the tenant called you and said, hey, I want to get an e-bike. I want to make sure I'm not breaking any rules. Like, can we talk about it? That's really the best practice so that you can do that. But again, tenants can be sneaky. Not all of them are, but some can be. So you really want to make sure that you know that you have those boots on the ground and you know what's going on in your units.
All right, we got some questions here. Jerry asked, what about e-skateboards, one wheels, EV cars, motorcycles?
Yeah, well, EV cars and motorcycles are probably a bit different, but this Senate bill basically covers personal micromobility devices, which are defined as a device that is powered by the physical exertion of the rider or an electric motor and is designed to transport one individual or one adult accompanied by up to 3 minors. So I think that would cover all of those. And I think that e-cars or the Teslas, the electric cars that we see are obviously a different issue than this.
All right, thank you. And Martha, the concern is a fire. Is there a storage safety involved or just the policy that the state of California requires?
So actually, that's a great question. And referring to the language in SB 712, it defines secured long-term storage as access is limited to residents in a housing complex. It's located on the premises. It's reasonably protected against precipitation, meaning you can't leave this e-bike, out in the rain. And it has the minimum standard electrical connections to actually charge the item, and that they're not charged for its use. So meaning if you're plugging in the bike or you're plugging in those things, all of those are factors. There is no specific that I'm aware of in regards to the question, it must be stored this amount of feet from the wall or things of that nature. That's really a more difficult question to answer regarding safety of storage. I believe that if you take the general framework of it needs to be in a dry place, it needs to be in a place that has somewhat of a temperature control, because as David mentioned, if it's hot outside, these batteries will burn up. And so that really is the framework. This Senate bill is really talking about people put it in their house. Look, I can understand if I have a scooter or a bike, I don't want to leave it outside. Someone can steal it. I'm going to put it inside.
They're expensive.
People do that with their bicycles too. Regular bicycles, they don't want to put it on the bike rack. They want to keep it inside. That's okay. But this is to protect on that issue. So in regards to about storage, you may want to double check with your own insurance carrier or company to see if they want you to do something specific. That might be a better way to answer that question.
Mm-hmm. All right, Janet, is renter's insurance enough to cover the item, or do they need a separate insurance specifically for the e-bike, e-scooter?
So my position is that the renter's insurance needs to incorporate the e-bike, e-scooter. If it's not incorporated at all, or you can establish that this policy is only for, let's just say, water damage or things of that nature, it's not the right policy. So if the tenant chooses to get this policy as one of the 3 criteria to allow storage inside the unit, you as the landlord must make sure that this particular policy covers this particular issue. I would not take general tenant renters insurance policies to cover this. It's very specific. So if your tenant goes, I have renters insurance, here's the policy. I would say, thank you for that, but can you please provide me something from the insurance company that says e-bikes, e-scooters are part of this? And if you get that document, I would say that's sufficient. If not, you have, again, if they're using that third criteria, then you would go in that direction. And remember, it's an or statute. So if they're compliant with no motor or they're compliant with the USA European standard, they don't have to have insurance on it. This goes to renter's insurance. So you do want to try to have that comprehensive policy. Fire is critical. Cause of fire is critical. And if the tenant has that e-bike and the tenant doesn't store it right or there's a problem and you have the fire, that's one of the most critical components as addressed in the question.
Yeah.
Great. And this is not just San Francisco law. This is for the whole state.
Right.
Doesn't matter where you're at in the state. Doesn't matter how many units you have, does it?
It does not. This is the statute is read as one bike per tenant or per occupant per unit. So it's absolutely correct. This is not isolated to Southern California. This is the Senate bill.
All right. And then we have Eric. Does a list exist which includes makes, models which currently meet US or European standard? If the device does not meet the standard, what type of policy would the tenant get?
If the device does not meet the standard, then my position would be that they probably won't be able to get a policy, because the standard under the European USA framework, which is where, as I mentioned, the Commission for Public Safety and those frameworks in the United States, as well as the European standard, say this is certified okay.
Yeah.
If they don't have that, no one's going to insure that bike because the insurance company is taking a major risk on a bike that's not compliant with the safety protocols.
And yes, there is a list. It's in the Senate bill. It's in the addendum. When AOA, check the AOA form, the standards and the codes for those standards are listed in that.
And to the specific point of the question, I'm not aware if there is a website that says the following e-bikes are legal or properly certified. There may be. Either way, the particular item or device that you get should have the stamp sticker certification on it. And assuming your tenant works with you and they send you a copy of it or they send you the registration information, you will easily be able to determine, based upon AOA's form and looking into Senate Bill 712, whether it's compliant. So you'll be able to figure that part out as opposed to just having a list of websites. And the other thing is, I don't know if this website would be accurate unless it's maintained by some general government agency. So it's better to kind of do it with a little bit of the elbow grease. Check the certification, check the registration, check the company, and make sure they are.
Yep.
Great. And then Karen, does this pertain to electric wheelchairs also?
No, it does not. So there is
Great
actually
question.
a specific carve-out for accommodations for a disability, assuming that the wheelchair is not being used for just off-roading in a new type of sport. If it is in fact paired with a disability, none of this will apply.
Great. And one of the other questions, there was a two-part question. One of them was, well, where are they supposed to work on this battery?
You know,
if
this
not in
is,
their house?
sorry to interrupt you, this is interesting because a lot of times in the lease agreements, you'll see can't work on your car in the driveway, right? You're not allowed to work on the vehicle on site because there's issues with, again, chemicals, oil spills, things of that nature, and a lack of knowledge in what you're doing. My thought process for when someone is going to work on such a product is it needs to obviously be in a dry, safe area, things of that nature, but I believe that you still are allowed to maintain the same compliance as you do regarding vehicles and working on vehicles and things of that nature. So I would associate the rules with that. You're obviously not necessarily having the same amount of work as compared to a vehicle if someone's changing their oil or they have that broken down car on the driveway and things like that. But this kind of also relates back to the fire marshal requirements and the issues for maintaining safety and compliance. So it would not be proper, in my opinion, in the parking lot of your apartment building to have a guy put out a tarp and start working on his e-bike in the middle of the parking lot.
I'll just say anecdotally, because my son does have one of these, there are now businesses that allow you to bring them in and work them up and make modifications and things like that. There are a few in Southern California, in the beach communities there. So I imagine if that does need to happen, there will be a supply for it as the demand increases.
All right, Janet, if we do not provide storage for the tenant, where can they store the battery? The garage won't work because of the heat. Where could they store it?
Well, I'm not sure the question suggests as if we do not provide. You're not technically, under the language of the law, allowed to not provide it. They're allowed to keep it. But assuming that it doesn't comply with the minimum standards, then that would be the tenant's problem.
To add to what David said, a landlord is not allowed to prohibit storage of the e-scooter or e-bike as long as it complies.
Yeah.
So it's not so much about, oh, well, we don't have a place to put it. They can store it in their home. They can't if they're not compliant. You're not required to have a garage for them or something like that. But remember, that's in the home. So we're not talking about if they have a lock on it, for example, and attach it to the bike rack. That's not what we're referring to. This is about storing this item inside, not being able to work on the item inside and having the protections inside. So if the tenant is going to leave their scooter outside their front door or whatever in their parking area locked, and that's fine, that's what it is. But again, I would still look to the outside issues of, is it covered, the precipitation, those issues. But again, a landlord cannot prevent use and storage as long as you have the compliance.
All right, well, I hope that clears things up here, and just kind of getting this out there. I think it's important. This is fire safety, and it's just smart to think through all these things. And I think sometimes people may not be in the right state of mind to think through things. Like your tenants may just not have thought about the fact that heat and charging just don't mix, right? And it's just common. We all make mistakes. And so I hope this is helpful for you. And for those of you that are in Northern California, we're going to have that maximum allowable rent increase seminar coming up here online at noon. And so stay tuned for that one. And hope we see you at the trade show or up in Oakland on the 15th. And we have a bunch of seminars that are going to be rolled out for September, October, November that are in person. And so you'll be seeing those sometime soon. And again, thank you so much for joining. And again, guys, thank you for helping AOA with
Thanks
the forum.
for having us.
And
feel free
else.
to reach out if you have any questions or concerns. Our info should be at the bottom of the screen.
There it is.
And I will add that we really appreciate if you do call us for any questions, comments, concerns. You mentioned that you've watched this or that you're associated with the AOA community, because we want to make sure that we're giving back to the community that listens to us, and so we will make sure to provide the time and attention necessary through that process as we benefit from providing the information, and we want to be helpful to those that benefit from this community.
Absolutely.
Oh yeah, and tell us, what area do you cover, just so people know?
So in respect to the landlord-tenant world and all the things associated with it, we handle matters for landlords, including the eviction process, compliance with leases, compliance with rent control, compliance with Section 8, things of that nature, up to evictions. Also, if landlords get sued, if they don't have insurance, for example, and they're defending habitability lawsuits and the framework of those parts of it, it really encompasses the broad spectrum of the nature of what AOA and its core values and what they're trying to do. And so we also have a lot of experience on the tenant side of things. That's what makes us different. We represent landlords and tenants, and we, of course, subject to conflicts, but we know both sides.
And we're in Van Nuys, same location as the office we're at. We service the whole Southern California area. We kind of draw the lines at San Diego, and we don't really go north of Mojave.
Mojave, but I think it's, we like to be a resource to help, and we really have a dynamic understanding of the perspectives of both sides, and that's why when we take a case on, we know what tricks may be coming from a tenant. We know what games may be being played, and we are very familiar with those things.
But so all of Los Angeles County, generally.
Yeah, and that was the question. I omitted the word geographical area.
We're in Southern California,
Southern California,
Los Angeles County. Give us a call.
LA, Orange County, San Bernardino, all those areas.
That's
not
right.
San Diego.
We don't we will, but we really try and focus on LA County.
Yeah. And San Diego, really, it's a different beast.
It is,
And,
yeah.
Yeah, so. All right, everybody, thank you so much, and maybe we'll see you at noon. Take care. All right.